Let's try that again. First of all, thank you for being here. I know in the past we haven't had August meetings for vacation schedules and so on, so I just really appreciate the fact that you're able to come here and serve and to ensure that we continue to make sure that the appeals go through the process and aren't delayed for a month because of that. So thank you so much. One quick order of business. The first thing I just wanted to draw your attention to is on the June 26th meeting, so not last month or the month before, there were two cease and desist orders that had been approved by the board, but were omitted from the minutes. So when the board approved the minutes from that meeting, two of those C&Ds were omitted. It was just a ministerial error. So I just want to ensure that you're aware of that and just correct that process. So is there a motion to approve the minutes from the June 26th with those two additional C&Ds added to it? Okay, thank you. And then on that note, is there a motion to approve the minutes from our last meeting of July 31st? Okay, thank you. And one abstention. Okay, so I guess the first item up on our agenda today is Arnaldo Hilton from Department of Buildings, who is going to be presenting on some new infractions and amendments to the penalty schedule. Arnaldo?
Thanks. Good morning. In your packages, I gave a letter, but I also gave an updated version to the board members this morning. It was a typo, just a minor typo. I typed 11 instead of 10 in the letter. But in 2008, the New York City Department of Buildings underwent a complete code revision, as you remember, and the new New York City construction codes, as it was called, also require that the department updates the building code every 3 years to be just to modify consistency with the to be consistent with the ICC version. So today I'm here to present and ask that you approve some new infractions as the 2014 update affected the penalty schedule, the ECB penalty schedule. Just to let you know that the New York City Department of Buildings also promulgated its own rule reclassifying or updating classifications of violations that were affected by this code review. This 2014 code update was contained in Local Law 141, which takes effect on October 1st of 2014. It amends the administrative code to do with the New York City Administrative Code, the New York City Plumbing Code, the Building Code, Mechanical Code, and the Fuel Gas, the New York City Fuel Gas Code. And these sections, basically, all it does was it was amended some requirements, added new requirements, and renumbered some existing requirements. Not a major thing, but it does, as far as notice goes to respondents, it does change some sections, so we have to kind of change the penalty schedule to make it fair. So in your packages, ladies and gentlemen, I gave you some updates, so an updated spreadsheet of the affected infractions, and I'm not sure if it's a lot of them. It's like 50. There are 3 deletions because, for example, the rules 1 RCNY 903 will not cease to exist. So we will remove those infractions that are no longer required. And there was one infraction on there about plumbing work not contrary to approved plans, which the department has never used. And so we want to just remove that penalty because they haven't been using it. Don't see the need for it because it's specific to plumbing, and we already have an infraction that covers all work contrary to approved plans. I just want to draw your attention to the second page of the spreadsheet, and it has to do with one of the highlights of the code revision was the changes to the changes to the illegal conversion aspect of the code. And as you recall, prior to, in the 2008 code, the first a class 1 or immediately hazardous illegal conversion was defined as a 1 or 2 family home converted to 4 or more families. And those infractions of that, those infractions then would subject the respondent to a daily penalty of $1,000 a day up to 45 days. The new code has revised what a class 1 illegal conversion would be. And in addition to those 1 or 2 families converted to 4 or more families, would be any occupancy other than office buildings, any other occupancy, including residential buildings, that add to their approved number of occupants, approved number of apartments or families, three additional. So, for example, a 15-family apartment building, if they were to add 3 illegal dwelling units, it would be classified as a class 1 and be eligible for the illegal conversion. Excuse me, the additional daily penalty aspect. And that's just, I think that was making the whole aspect of class 1 illegal conversion a little more fair. Before there was really on the backs of 1 or 2 family homes. You had to start off at 1 or 2 family homes. Now it would be any kind of egregious illegal alteration of the building to add 3 or more families. And so we had to add some new infraction codes to cover those instances, such as multiple dwelling converted or maintained or occupied with 3 or more families, other than that's legally authorized. And the second one is industrial or manufacturing building converted to 3 or more families. The yellow highlights will show you some additional ones that we made. So we were requesting, for example, to fail to comply with the manufacturer specifications that are on equipment being used in construction equipment. And we've added a class 1 and 2 charge on that. And fail to maintain or display site documents required, on-site documents required by the chapter 33, which is the construction, building construction chapter of the code. We've also asked for new infractions such as fail to perform slurry operation in according to section. Slurry operation is, oh, by the way, I didn't introduce someone that came with me, I'm sorry. I have Charles Shelmer with me. He's a code analyst for the department, but I think I prefer to call him a code expert. He is very much involved with the code revision, and so Charles, I'm sorry. Slurry operations in accordance with section. And slurry operation is actually concrete foundational kind of work going on with it. Slurry, picture of slurries, concrete slurry, correct? That's reported to foundation. And that's very serious, so we've asked for immediate, that violation to be immediately hazardous. And fail to obtain a registered design professional's evaluation prior to using existing structures to support formwork loads. And formwork is also concrete work. That's class 1. No site-specific form work design drawings present. That's also a class 1 request. And fail to perform required formwork observation, which means that during the formwork operation, there must be someone there constantly monitoring the work. And fail to do so would be a class 1. Immediately hazardous infraction. The penalty amounts requested are there, and if you have any questions about that. But just so you understand, the existing an existing infraction, we never changed any penalty amounts. Only for the new infraction we requested penalties. We just modified the code sections as the code changed. We modified the code sections in the penalty schedule to be consistent with the code, with the law. And the inspector has to specify, for example, if they're citing to the 2014 code or the 2008 code, because the requirements did change in the ones that are asking for it. There may be a different requirement that was added in the 2014 code that never existed in 2008, so that the inspector, if a job was filed after October 1st of 2014, which is when the code takes effect, the inspector must charge the 2014 code section. And so that's why you will have in red a notation there as to which code we're charging. And with that, I'm just requesting that council schedule.
Well, I have a few quick questions just to make sure I'm looking at the right things and that we're all on the same page. So I'm looking now at the spreadsheet, which is a 4-page document.
Yes.
I'm looking at the second column from the left, and there are markings in here in red. So I'm looking at the sections in red as the modified sections, right? The sections that have been, where the enumeration has been changed.
Yes.
Okay, so I'm looking, so that is just reflecting the 2008 versus the 2014.
That's right. That's right.
Citations. And then all of the highlighted bits, the highlighted insertions, so there are 11 of those, starting on page 2 and continuing through the document, would be all of the new infractions requested.
Yes, which takes effect in 2014.
2014. And as you said, any inspection that occurs on or after October 1st, 2014, this would apply.
Yes, the entire thing would apply.
I mean, these new
ones,
right.
yes. These new ones do not apply right now.
Okay. And then the penalties that go with each of these new infractions, where I
Okay,
tried to
so
see
the
header of the
header,
page
yes, did not cover.
so
Yes.
it would be,
So the penalty
It would
is
be
the
the
first
standard
column,
penalty.
the standard penalty column.
Okay.
The other penalty columns are just bylaw definitions of what, say for example, the default penalty is just 5 times the standard penalty. So we really should just look at the standard penalty column as the approval.
as the approval piece, okay. So just to be clear, I'm looking at the second page of the spreadsheet. It is the first of the newly requested infractions. It is a class 3, and it's numbered as 28.118.321.
Yes, sir.
And I see that the penalty that I would be looking at as a standard penalty would be 400.
That's right.
The second one on that page is 2,400.
That's right.
The third one would be 3,200.
That's right.
Okay, all right, I understand what I'm looking at now. Okay. Any other questions from the board? Elizabeth?
Elizabeth Nauer, citizen member. I had a few minor questions about some of the violation
Sure.
descriptions.
What page?
So for the ones that you were just discussing, the new class 1 violations for 28-210.1
Yes.
for conversion. Though it seems like from the description, it seems like there's a word missing because it says multiple dwelling converted, maintained, or occupied with 3 or more dwelling units then. It seems like it should be 3 or more dwelling units then. You see what I mean?
It's 3 or more dwelling units that
Then.
legally authorized, or other than, but
But
then.
it's not 3 more dwelling units then, it's 3 or more dwelling units than legally authorized.
Multiple converted
I know
or
that's-
maintained with 3 or more dwelling units.
3 or more, shouldn't it be?
No, it's already a multiple dwelling, and you're
Right.
saying you're maintaining with 3 additional.
It's not 3 more though, it's 3
Or
or more than are
Additional. You mean
legally
additional.
authorized.
Yeah.
There's
multiple
there's a
dwelling.
word, I mean, I know, 3 or more, I know doesn't sound very,
Well, because the
Eloquent,
last phrase
but-
says that legally authorized.
but there's nothing before then. There's nothing describing what,
3 or more dwelling units than legally authorized.
So give an example.
I understand what the concept is.
Yeah.
I feel like there's just a grammatical error here because
I don't
if
think
it
it's-
said 3 more than legally authorized, that would make sense. But it says 3 or more, meaning 3, 4, 5, 6, etc.
Yes, that's true, though.
And then you have to have another word, 3. I'm having trouble.
I understand, but let me explain.
It's a
though.
syntax.
So let me explain, yeah, I understand what you're saying. So multiple dwelling converted, maintained, or occupied with 3 or more dwelling units.
More
That-
than are legally authorized.
Well, the word "than,"
Took out 3 or, just said the sentence.
Three more.
If you took
But
out
then it-
3 or,
But then it would just
you would
be,
just say with more dwelling units than.
that would
So
make
that would be
sense, but it's that the more is being used to
the more-
describe the number of units. as
Of
opposed-
existing units.
Mhm.
So is that what you're saying? So
Well,
for
no, it's-
example, if you have a multiple dwelling with 3 units,
If you had, well, no, what I'm trying to say is that the way it reads is it's describing 3 or more dwelling units, right? The 3 or more is what's being added,
Yes.
3 or more. But then is not modified to say, it should be 3 or more dwelling units in addition to what is legally authorized, or something like that. That would make more sense.
that would be the perfect English
Right.
there, but I still think, yeah, I understand, but I still think it
I don't
conveys.
think it's
You don't think so?
grammatically correct, no. But,
Okay.
You have to just clean it up a little bit. It just needs to be.
I would suggest,
do you think that
Dividing
somebody
it.
reading this would not be on notice for, do you think that the description is misleading in some way? Or
I
could
don't-
be misread?
Yeah.
Yes?
Yes.
Okay.
only because it doesn't really make sense. So I think it's, one can, decipher it, but it doesn't
Okay,
clearly make sense.
okay, I understand where you're coming from. This has also passed the law and the mayor's office review already. But, I mean, I don't know if, yeah.
The other concern is that all the other violations read this way, so if we changed it in this one, we would have to change all the other infractions.
Which one,
Because then they would be providing different notice, which would make.
which ones,
Is
which
this-
ones are you referring to?
So if you look at the ones that are not highlighted, and you look at the ones directly above.
Yeah, but that,
Directly above.
those
and
make
you look-
sense. Those are for, it's.
4
it's
or more families.
for 4 or more families, but there's no, what I'm saying is that there's nothing describing what then, there's no comparison word. So it doesn't apply, the other ones, I don't think, I think the other ones make sense because it says for 4 or more families.
Okay.
It's not the same
I
issue.
understand. Would a change to this be, just to clarify, change the,
Yeah, I think it's.
so we'll.
Yes, Russ?
In your letter and all though, the italicized language on the second page, is that the actual text of what we're talking about?
Yes.
Well, that's what it says in the actual text.
In the
3
actual
or more
code.
dwelling units then are legally authorized.
Yeah, this
That's
is
the way
actually
it
come from
reads
the code itself.
in the text.
All right, well, I mean, I
But
can't,
if you think, I
that's
mean,
not
I
our
think,
bailiwick.
well,
I don't think it has to match the code exactly. So if it's really confusing.
if it's really
you can
confusing, I
change
believe
it.
we can, in the ECB's penalty schedule, we can just.
Insert.
Insert the word
Additional.
other.
Or additional.
In addition to,
Okay.
Additional itself is, I think, the only extra word that.
yeah, additional or something to just
So read
add.
it, say it back to me how you would
Um,
propose.
Well, how I would have proposed it, multiple dwelling converted, maintained, or occupied with 3 or more dwelling units in addition to what is legally authorized. But if that's changing it too much,
3 or more
Dwelling
additional
units.
dwelling units then.
yeah, 3 or more
Yeah,
additional
additional
dwelling,
dwelling.
yeah, that's just adding one
Okay,
more.
so we're just adding
And that's-
additional in front of the word dwelling.
And I had one other,
Okay, that's all.
Okay, so we're
That would-
done with that.
that would be for those 2,
So just the word additional in front of dwelling units, right?
yes. And then.
For the 2 charges there that are highlighted.
The 2 new class 1 charges. And then I don't have page numbers on my printout, because this is on my computer, but it's before 4 highlighted rows, a couple of pages later.
But hey, are you using the same one?
No, she's not.
I'm not, because I had marked,
I can-
We're
oh.
looking at the 3rd page.
I think it should be the 4th, I think it's the 4th page.
4th page.
Yes.
The very last page of the document where the highlights are on top.
No.
Just Just tell me the charge and I'll find it.
Okay, it's, the charge is BC, the section of code is BC 3303.8.1. It's not a new infraction,
Oh,
but
it's
it was
not, okay.
modified.
3303.8. Charles, do you know where that?
It's in the
Failure.
third page of the last row.
Oh, I'm sorry, is this, the rows are different?
It's B1C3.
B1C3, right?
It's right staff type or air pressurized.
So, this was actually not in, the issue wasn't the violation description, but the remedy. Because the violation description was changed to say failure to provide standpipe or air pressurized alarm system. The remedy is just provide air pressurized alarm system. Is that correct? Or should standpipe be in the I don't know the answer to that, but.
Oh, I see.
Standpipe is
I
the
see,
remedy
okay. I
as
take,
well.
yeah, I'll take that into advisement. The remedy here is not for ECB, it's also, we'll make
Okay,
sure we change
okay.
that in. But yes, you're right. Thank you.
That was it.
Okay, any other questions for Howard?
Yeah,
Yes,
Jorge
go ahead.
Martinez, DOH. I just have a basic question. When do aggravated one penalties and aggravated two penalties kick in? What?
Okay, so the law defines aggravated one as the same charge or section of law on the same property, the same respondent within a 3-year period. So if the inspector notes that he was charged with it before, within a 3-year period, same exact thing, same respondent, then aggravated one penalty will kick in. The law defines an aggravated two infraction as anything, I can remember, that causes or might affect a death or injury to someone or something like that. Right? It rises to aggravated 2 level, or if there's a history of non-compliance with that respondent throughout the city. So not a lot of, well, there are a lot of charges for aggravated one, but mostly with fail to comply with the commissioner's order, and you have to keep going back and back and back. But these penalties may never be used sometimes on these particular charges. They're just there as a placeholder, just in case we need to ever use them.
Anything else? Is there a motion to approve the penalty schedule concerning the 2014 construction codes? Anyone in favor? Anyone against? An abstention? No, of course.
Thank you.
Thank you. Okay, next up we have Russ McKinnis from DEP regarding the request for cease and desist orders. Russ?
Okay, good morning. There are no requests for air, noise, or boiler C&Ds this month due to August vacations. We couldn't get the paperwork together on them, but we will have those back in September. For this month, we have 28 new backflow cease and desist requests. We are also bringing back one from the July 31st meeting that was pulled back to review a possible discrepancy in one of the addresses, I think specifically the mailing address. That one is 2814 West 36th Street in Brooklyn. The respondent is Ali M. Twaidi. The mailing address has been verified, it is correct, so we are resubmitting that one that was pulled back on July 31st, and then there are 28 new ones.
Any questions for us on any of those 29 backflow CD requests? Okay, we'll vote on those collectively. Is there a motion to approve? Anyone against? An abstention? Yes? Okay, thank you
Thank
very
you.
much. Okay, and then now we have Kelly Corso from ECB, who is going to be presenting the pre-sealing reports.
Good morning. We have 18 pre-sealing reports today for the board. 4 of the reports pertain to violations of the air code that are related to boiler burners. In 2 of those cases, the judges recommended that the C&D proceedings be discontinued because the respondents are no longer the managing agent or the owner of the properties. In the other 2 air code cases, the judges agreed with the DEP's recommendation that the C&D orders be discontinued because the boiler burners have been removed from the properties. The 14 remaining reports are pertain to backflow violations. In 13 of those cases, the judges recommended that no sealing or other action be taken given the respondent's compliance. And in the 1 remaining backflow case, the judge recommended that the C&D order be discontinued because the respondent is no longer the owner of the property. And that's all we have.
Okay. Any questions for Kelly on any of those pre-sealing reports? Air, backflow? Okay. And is there a motion to approve? Anyone against? Abstentions? Russ? Okay. That was easy. Thank you, Kelly. Okay. Okay, at this juncture, we will have to move to go into executive session to discuss the appeals and litigation. So is there a motion to approve? Is there a motion to executive session? Okay, thank you. So anyone who is not a member of both ECD will have to excuse us for the time being. Okay, we are back in public session. I just want to note for the record that during our executive session, we discussed a litigation matter that presented a conflict for us. Now, Elizabeth recused herself from the meeting for the duration of that discussion. Okay, now that we are back in public session, we have appeals that were presented at panels on August 7th and August 21st. Is there a motion to approve the appeals? Anyone against? Abstentions? None? Okay. I think that is all of our business for today. Anything else before we adjourn? Okay. Motion to adjourn. Thank you very much, everyone. See you next month.
Yeah, 55.